to the City of Miami Commission meeting for April 25th, 2024. Our meeting is now in session. And at this time, we are going to take up the budget item.
Good afternoon, Madam Chair, Commissioners. How are you all doing? Okay. Thank you. This item is, I do a quarterly presentation of the projections for the year for the budget, and I also send out a monthly projection every month. I can go to all the details, or I can go to the summary.
Advance to the summary.
Okay. Okay, and this summary, this is the summary of where we are projecting the year to be through March of 2024. We projected that revenues will be $1.088 billion, expenditures will be $1.060 billion, which revenues will be exceeding expenses by $28 million. The internal service funds, which include innovation technology and the risk management, which is really inter-fund expenditures that goes into those funds because they are internal. For $3 million, we're talking about the surplus will be about $3 million. So the net of all funds surplus is about $31 million, 31.1. And then the building fund, which is part of the general fund in a separate category, those dollars are for the reserves for the building fund, for building activities function only, and that's statutory. It's about $11.2 million. So we net end general fund projected surplus of $19.8 million. Part of the general fund also has $5 million of contingency reserve, which we're going into the hurricane season. We need to put that aside, which reduces it to $14.8 million. And we still have some stuff that's coming up, especially the labor contract. We're not done with fire contract yet. So we need to keep that into consideration. And there's some stuff that we'll be bringing in May, the second meeting in May, for some items that we need to approve. That's probably going to take some of those dollars as well. So at this point, that's where we are through March of 2024. Do I have any questions?
Does anyone have any questions?
No.
Thank you for your presentation.
Thank you.
We left off on RE5. Do I have a motion for RE5?
Motion. Or second, or
I have a motion. Do I have a second?
Second it?
I have a motion and a second for RE5. Any discussion? All in favor?
Chair.
Aye.
I'm sorry, wait, Todd.
RE5 is to be amended to add the following resolution number, R-24-0153.
Thank you. All in favor?
aye.
Aye.
Motion carries.
As amended.
As amended. RE6. Yes, sir.
Of the auditor?
Mm-hmm.
Okay, I'm all for it, but the thing is, because the auditor is going to, his contract is coming up, right?
Yes, I
I
believe
got
so.
something for that.
Okay, no, because what I was going to suggest is that we just hire, if he agrees, on month to month.
On a month-to-month basis.
That's it. If,
Until the other item that we just passed.
That's what I had in mind. The same thing.
Oh, well, we are on the same wavelength. Good. Okay.
Okay, so RE6 is proposed that the Auditor General will be on a month-to-month basis.
Yes.
Mr.
Ma-
City Clerk.
I think the city clerk and I are thinking the same thing, Madam Chair, that they're the related items, so that's RE15. Commissioner, that's RE15. RE6 would be a charter amendment that would remove.
Okay, I move
okay.
it. I move
Second.
it.
So I have a motion and a second, as amended.
Yes, to add resolution number R-24-0154.
So I have a motion and a second. All in favor?
Aye.
Motion carries unanimously. 7 is withdrawn. 8 is deferred. We have RE9.
Yes.
That was the city managers, I think,
For what? RE9?
nine, I think. Was that you?
RE9 is in play.
Do I have a motion for RE9?
Motion?
Move it.
I have a motion and a second. All in favor?
Aye.
Aye.
Motion carries. RE10.
Madam Chair,
Yes.
I have a little problem with RE10. You see, what it says, it remove the covenant that we have. They're going to receive, benefits from the city. And according to a resolution, as I explained this morning, when we were talking about the affordable housing, it says 50% of them at 120 or less. According to a resolution, it is 100%. And it is, as I said before, it is a great difference because at 20%, at 120, they can charge $2,200 for a studio versus $1,700 at 100, which is the quite difference. If we are offering affordable housing, we need to afford and offer real affordable. You see?
Let me have the sponsor of the item respond to that.
Yeah, we talked, they came in, the ladies came in, and we're not giving them any financial benefit in that way. We're only...
The covenant, if we don't do the covenant,
Right.
they're not, they
They can't do it, but my point is, we're not giving them any monies, we're not giving them, all we're doing is making it so they can do what they want to do. But I understand your point, but I just want to clear it up that we're not giving them really any financial benefit in the ways of monies coming from the city, or what have you, in that.
Who owns the land?
We do.
We do. So they're getting benefit.
Yes, yes.
They're getting benefit. Land has value. Okay?
I don't know, I was just told that we do not own the land, is that correct? We do not own the land.
The city does not own the land.
We don't own the land?
No.
Well, I don't know. I'm not too clear about that, but you know the way I am, anything that it goes, comes.
Well, let's have administration confirm who the landowner is.
That's right. Just confirm who
I'm
the land
fairly
is.
certain the city does not own the land that the YMCA is proposed to build on.
Then why do we have to vote on this?
Because we got to clear the title. There's a cloud on the title because of the one side says one thing and the other, and what we're trying to do so they can do their project. It's just a matter of interpretation of the title, to clear the title. It's a small cloud that the title has, but we're not giving. It's not our land. It's just that they have.
Well, let me hear it from the.
Yeah, absolutely.
Let me hear it from the. Okay.
We could move on to the next item
Yes,
if you'd like.
Let's move to R11.
R11, do I have a motion?
Move it.
Yeah, I'd like to make a motion to ratify Coconut Grove bid Executive Director Mark Burns.
Okay, I have
second.
a motion. I have a second.
Second.
I have a motion and a second. All in favor?
Aye.
Motion carries unanimously.
Okay.
RE12? You want to take up RE12?
Sure.
Sure.
Okay.
There are a couple of small things I would just wanted to make mention because they've been floating around. I just want everybody to know that that process was entirely done in the sunshine.
Yes.
All the meetings were noticed. All the meetings welcomed the public. All the meetings have minutes. And I also wanted to thank the very distinguished selection committee that we all put together. And then the selection was George Wysong. So it's up to us to go ahead and vote.
To the chair, I want to add that if the period of application was extended for other people to apply to it. If only 13 people applied and most of them didn't qualify because they didn't meet the requirements that we as employer, we had those requirements. I mean, the selection, I believe that is crystal clear.
Commissioner, pull your mics down.
Here's the only problem that I have. If we establish a process, then it should be a fully transparent process where no one that applied and qualified could say that this is a sham by us. We haven't established any process to give the opportunity for those candidates that qualified to be interviewed by us. So what I will be asking is to bring this back at the next meeting during that week and a half or so. Go ahead, and any one of us that needs and should, frankly, meet with all the candidates that qualified, and there were many, do that. This way, no one can challenge what was done. And this is only being fully transparent in the process. And I've never, frankly, seen a process that you ask people to apply and then they're not interviewed by the ones that make the ultimate decision. I was not given by the city attorney's office that I believe was handling this, or by the administration, any guidelines as to how we were going to go about in interviewing people. So there has to be a process that we could give those that qualified the opportunity. I think the best way is for us to be able to do it individually. But if not, the other way is that you bring them all before the commission, and we could publicly ask them whatever questions we want done. So what I'm respectfully asking is that this would be held back until, when's our next meeting? Is it May the 11th?
May 9th.
May 9th? For the May 9th meeting, you have Mr. Greco in place, so that's not an issue anymore. And then we come and we handle business on May 9th in a transparent way that no one can point at us and say, hey, why did I even apply for it? These guys had it all fixed from the beginning.
Madam Chair?
May I? Yes. I thought the process that was used was one that we all came up with. We would select a committee. We appointed a member of the committee to do exactly what Vice Chair is speaking of. For me, I am confident in my committee appointments recommendations, so I don't need to go further. I'm just saying, for me, I don't feel like there needs to be an additional process, and I'll allow my colleagues to weigh in as well. I believe Commissioner Reyes.
Yes. Let me add. You see, the selection committee was formed to get politics out of it. But the process to have transparency. We are not interviewing and we are not making the decision. we are accepting the decision of that selection committee that was all, and I thank all of them, very reputable professionals that they gave us their time. They interviewed, they went through all the applications, and they make the selection. That is what we all agree, and that is what I am going to vote on it. I don't want to interview or to ask questions to any one of them, and I don't want to vote for a candidate based on their answer, because we are getting politics into it. You see, it's us politicians the one that are picking them up. That's the idea. The main idea was to get us out of it. You see, get us out of it, and that's why I don't. With all due respect, Commissioner, I don't see that we should.
Madam Chair.
I am.
Let me hear from my other colleagues, Commissioner Gabella.
I think we're ready to go. I make the motion. I think I see him nodding. I see Manolo. I think we all agreed to this 2 months ago. Like Manolo said, the application process was even extended an extra, I think, 30 days to allow more people in, and this is what we have. So I'm ready. I call the question, and I'm ready to.
Hold on,
making the motion.
Let me allow Commissioner Pardo to speak as well.
Yes.
I'm ready as well.
Vice Chair.
Chairman, look, no one told me that we were given the right to a committee to decide, and we were just going to rubber stamp whatever a committee made. If we're talking about keeping politics from it, then we should not have appointed the committee members. It should have been someone that's not in the field of politics. But nevertheless, it was not established that we were going to just approve whatever the committee would say. I personally have no problem when the committee recommended, but I've never seen in 40-plus years this process be followed here in this fashion. And what I don't want is anyone that applied to say, you know, these guys had a sham. They had a candidate they wanted from the beginning, and we were just used, not even given the opportunity from those that make the final decisions, that are the ones that are elected, to have even spoken to me. I don't know who these other candidates are. I know the one that's from the city that I worked with for many, many years, but I don't know the others. And I think if they applied, that at least would have deserved that opportunity. So this is the point that I'm trying to make across, that I think we all know where we're all going to be heading a week from now, or 10 days from now, whatever the amount of days are for the next meeting.
Call the question.
What I'm saying, that I think that there should have been somewhat of a process to be followed, to be a lot more transparent in how we move forward. If we're going to say that we're given our vote to keep politics to committees from now on, how many committees are we going to be bringing in to do that with? So we're going to be, maybe the committee people should be the ones to get the title of commissioner.
Well, let me tell you something. Through the chair, you see, you remember when...
Hold on a second. I understand what our vice chair is saying, and it was my understanding that we appointed the committee to make recommendations. We do not have to accept the recommendation.
No, we don't.
That's exactly what I'm saying.
So this is what the vote would be. I was advised by the city clerk that I have a motion from Commissioner Gabella, but I don't have a second.
Well, I'll second it for the sake of speaking and being able to finalize this. But the question that I'd like to ask is, I'm confused now. I was told that the committee had asked for an extension so that more people could apply. and they were told no,
No,
that they couldn't do it.
There was an extension.
there was an extension.
There was an extension.
What they asked, then let me refresh your memory. What they asked for was to place their own requirements, what they thought that were the requirements, is they were the employers.
Yeah.
And all of us said, no, we
Yeah,
are the employers.
Yeah, we said that, and we have a right
Okay,
to
and
do
that's
that.
it.
Yeah.
And I'm just going to remind you this, excuse me a minute, I'm going to remind you this. When Acevedo, when Acevedo was picked, he went over the committee that we had already get together, and the committee had their own, I mean, they had their recommendation, and we went over Acevedo. I think that what we have here is a process that was totally performed according to what our instructions were, and too bad if the more people didn't want to work here. There's a lot of people that don't want to work in the city of Miami because the way that sometimes we behave, and that's the truth. I mean, we cannot lie to ourselves, and the people should know that. You see, that's a fact. So I second Mr. Gavela, and I think that we should be voting.
Okay, let's call the vote.
So I have a motion and a second. All in favor?
Aye.
Aye.
I will be voting no for the reasons stated, even though I would have voted otherwise for Mr. Wysong to keep someone from the inside in helping bring this department forward.
So motion carries 4-1, and at this time, the city
As
clerk,
amended.
as amended, the city clerk needs to administer the oath for Mr. Wysong.
And Madam Chair, just to be clear, this is for this election. Later, we will have compensation package.
It's okay.
Everyone ready? Ready. Raise your right hand and repeat after me. I state your name.
I, George A. Wysong III,
Do solemnly swear
do solemnly swear
that I will support,
that I will support,
protect,
protect,
and defend
and defend
the Constitution and laws
the Constitution and laws
of the United States of America
of the United States of America
and of the state of Florida
and of the state of Florida
and the Charter
and the Charter
of the City of Miami,
of the City of Miami,
and in all respects
and in all respects
faithfully discharge the duties
faithfully discharge the duties
of City Attorney
of City Attorney
of the City of Miami,
of the City of Miami,
Miami-Dade County, Florida,
Miami-Dade County, Florida,
to my colleagues
to my colleagues
and to all of those
and to all of those
I represent and serve.
I represent and serve.
I pledge fairness,
I pledge fairness,
integrity,
integrity,
and civility
and civility
in all actions taken
in all actions taken
and all communications made
and all communications made
by me as a public servant.
by me as a public servant.
Congratulations.
Thank you, sir. Thank you, everybody, for being here for me, a momentous occasion. I believe in the oath that I just gave. I will protect, preserve, and defend the laws of this great city. And I intend on working with all of the city family with fairness, kindness, humility, and respect. So thank you so much for appointing me, and I hope to do you proud and propel our office to the future. I'd like to give a great thanks to my staff, and Thank you, everybody. You're wonderful attorneys and colleagues, and let's get down to business. Oh, I just made the worst transgression possible. I would like to thank my lovely wife, Brenda, for all the kindness and support. And thank you, Brenda. And my two daughters are tuning in at home, Alexandra and Cassandra. I love you. Thank you.
Madam Chair, I'd like to thank John Greco for his 3.5 days of service as city attorney. He did an exceptional job.
Are we ready for RE10? Do we have the answer for RE10? Are we ready? I could go to another item if we don't have the answers yet.
So, Madam Chair, through you, can I answer a question?
Yes, yes.
So if you want the answer, I think the gentleman, this is the attorney for the YMC, for the group, and maybe he can answer the question that Manolo had?
Yes.
Of
Good afternoon.
Good afternoon.
Can you confirm whether the property is owned by the YMCA or the City of Miami?
The property is owned by the YWCA of South Florida.
I knew that. Okay.
That's satisfying me.
So I have a motion and a second. All in favor for RE10?
Aye.
Aye. Thank you.
Chair,
Thank you.
can you just clarify who the mover and seconder was for RE10?
I think Commissioner Gabella was the mover. I don't know. And Vice Chair was the second. We have RE 13, 14, 15, and 16 in play. Does anyone want to take any one of those items out for discussion? Take out. So is there a motion to defer RE 15?
I'm sorry, sir? Well, Mr. City Attorney, then that just means, what does that mean for the current Auditor General?
So the only concern is, and I believe his date is May 8th. The next commission meeting we have is May 9th. So you could, by deferring it, you could trigger arguably a new term of 4 years. So,
Yeah, I think the fear is not to trigger a new term or not to give any impression that we're triggering a new term,
Correct.
which was why we had indicated in the briefings that it would probably be preferable to have this be a month-to-month agreement up until the ballot item is, and the charter changes is addressed by the
determined.
voters.
So would that be an amendment to this item?
Yes.
I think so. It will
Okay.
be month to month,
Yeah.
up until this is voted upon.
Okay.
right, exactly.
Okay, that's fantastic.
That's the
Month to
idea.
month,
What
that's
Carolina
right.
said, that's the idea.
Okay.
That's right.
So,
I move it.
okay.
Second.
So then do I have a motion for RE 13, 14, 15, and 16?
Todd has his hand
Move
up.
it.
So then for RE15, we have a blank for the name. That is Theodore Guba,
Yep.
correct?
Correct.
And on a month-to-month.
On a month-to-month basis, as amended.
RE15 amended. There's also, the substitution memo was distributed on April 24th regarding that's FR2. I'm sorry.
Okay. So I have a motion and a second.
RE16, there was a substitution memo distributed on April 22nd, 2024, amending RE16.
So as amended.
As amended.
So I have a motion and a second. All in favor?
Aye.
Aye. With RE 15 and 16 as amended. Okay.
We didn't do 13 and 14?
We did 13. We did 13,
That was the whole
14.
thing, 13,
Yeah.
14, 15, and 16, right? Okay.
Okay. SR1, outdoor advertising.
Madam Chair?
Yes,
I'll go ahead and open
please.
on the item we're sponsoring. The first thing I'd like to say is thank you to everyone who came out to speak on the billboards. On whatever side you were, it speaks to our residents and to our conviction and to our voice being heard by government, and you making the sacrifice and taking the time to participate in this process. It's so important. I talk a lot about it a lot because I want you to believe it. So believe it. SR1 is a compromise ordinance. This is important to understand. It already passed at first reading, and I'm asking for us to vote it as is. It repeals the ordinance that passed 1.5 years ago. That's the ordinance that created these oversized outdoor signs when there was no District 2 commissioner. It also leaves existing permits in place. Why does it do that? Because we want to avoid liability in the city. And were we to take vested permits and deny them or change them, we would be accruing large amounts of liability for the city of Miami. We are asking for no amendments to be approved. Why? Up until now, these have served as enormous distractions to what we're really trying to do here, and they're usually distractions put forward by special interest. As far as the ARSH falls under RTZ zoning, Miami-Dade County zoning. I spoke with Mayor Cava 2 days ago. She assured me that she has spoken with the ARSH leadership. She informed them that RTZ zoning in the county applies for the ARSH and that she would be willing to explore pathways with them. As far as the PAM has a lease with the city of Miami where we are the lessor. We cannot treat them or give them or convey special privileges to the PAM. We are the lessor. And in our fiduciary capacity as commissioners, we must preserve the rights of the lessor. So we cannot include the PAM. As far as anything else, there's not enough information and it hasn't been vetted, and we can always come back to this ordinance at a later time and address those. So I'm going to take a brief moment as well. I'm going to ask the city attorney if he could speak to two aspects on this ordinance. One is the potential liability, and the other one are the amendments that I've just referred to.
Okay, by potential liability, you're talking about if the city of Miami were to adopt this ordinance as is, would there be any potential liability? Our belief is that you have heard over 4, 5, 6 or more occasions individuals come up and discuss the various legal positions of the sides. And however, it does not appear that just by adopting this ordinance as is, there would be any significant liability or any liability. You know, we have indicated that those properties that have already applied for permits are able to undertake an estoppel argument that the project has already been, permitted, built, constructed, etc. And we're comfortable with that. And I have not heard any of the commission members indicating that we are going to go after or remove these signs. And I think it's important, after listening to the public comment, some folks thought that by adopting this ordinance, those signs were going to go away. That's not the case. And the signs will be there, but they will be there in a non-conforming status, and which means they can stay until they're essentially taken down or abandoned by the sign companies. So as far as liability, full disclosure, could somebody say, I'm not comfortable with that? The city has said that we're stopped from enforcing it. Could they file some sort of action? The only action I would foresee is like a declaratory judgment action where they would try and ascertain their rights. That would just be an opportunity for the court to determine whether there are estoppel rights or not. We have said there already are estoppel rights, so it wouldn't be much of a case. So on the liability aspect of it, I can't look into a crystal ball, but it does not appear by adopting the ordinance in an as-is fashion that would create any exceptional liability situation.
Thank you, Mr. City Attorney. Now, would you please read in?
I wanted just
I'm sorry.
one
Go
more
ahead.
little bit.
Go ahead.
I just wanted to say that the District 2 office has been dealing with this for 4 months daily. We get the phone calls, we get the emails, we go to the forums, we hear directly from, I would say, hundreds of people. And so I just want you to understand that we've tried our best to really gauge what's in our district. We put out an Instagram poll, we put out a text poll, we geofenced the boundary. 80% plus do not want these signs. I feel like the public has been very, very clear, and I'm going to ask my colleagues to please support me on this item as the District 2 Commissioner with this compromise ordinance.
So I want to do that. I listened to everyone that came up and spoke throughout this whole process, the folks that came and spoke in favor and the folks that came and spoke against. I have an amendment that I believe is also a compromise because, as the city attorney just said, the signs aren't coming down. We can't take the signs away, but I heard them about the light, about how big the signs are, the number of signs. So I would like the city attorney to read into the record the compromise that I am proposing so my colleagues could at least hear it, and so the community can hear it as well, because the sign won't be on with my compromise 24 hours a day. There's a time that the sign will come on, and there's a time that the sign will go off. It won't be 24 hours a day, but so that the attorney, Mr. City Attorney, can you read my compromise for the record?
Yes, Madam Chair.
To be considered.
So this would be based on the item on the agenda. The following shall be added to subsection A. And there might be some tweaking of the formatting, but parentheses 6, digital freestanding signs is defined in subsection 2-779A6I, located at the Olympia Theater and Building, Gusman Center for the Performing Arts, 174 East Flagler Street, Perez Art Museum, PAM, 1103 Biscayne Boulevard, and the Adrian Arch Center for the Performing Arts of Miami-Dade County, Adrian Arch Center, 1300 Biscayne Boulevard, Miami, digital freestanding sign sites, parentheses, shall be allowed to move forward with permitting, construction, and operation in accordance with the regulations found in Ordinance 14140, including repair, maintenance, or reconstruction of the digital freestanding signs, irrespective of any contrary provision contained in Ordinance 15416. Notwithstanding the foregoing, such signs may not be exempt from Section 2779A6 and Section 2779H of Ordinance 15416 and must comply with the following. 1. Only one sign structure with 2 sign faces will be allowable at the Adrian Arch Center. 2. The digital freestanding signs pursuant to Section 2779A6 are entitled to be erected in accordance with Ordinance 14140, notwithstanding any contrary provisions in Miami 21, the city's zoning ordinance, where applicable. The digital freestanding signs cannot exceed 1,800 square feet per sign face, with no more than 2 sign faces per digital freestanding sign, and with the height measured from the top of the sign face not exceeding 100 feet above grade. 3. If Miami-Dade County retains jurisdiction to process the permits for the digital freestanding signs at the Adrian Arch Center due to its RTZ zoning designation, the county shall review such sign under Ordinance 14140, as provided in Section 33-82C of the Miami-Dade County Code of Ordinances. The city has opted out of the county's sign ordinance for all signs located within the city's urban core. Then the following shall be added to subsection F. 4, parentheses 4. The city may rescind a sign permit issued pursuant to Section 2-779 for a violation of the sign permit upon providing the permit holder notice of the violation and allowing the permit holder a reasonable period of time to cure said violation. Subsection H shall also be added. H. Restriction on signs. 1, hours of operation. Sign faces may operate only during the hours of 6 a.m. to 11 p.m. Notwithstanding the foregoing, if an event is taking place downtown, sign faces may operate only during the hours of 6 a.m. to 12 a.m. When sign faces are not in operation, the screen shall be black, but an unobtrusive logo listing the name of the venue located at the site can be present. 2, modulation and ambient lighting. From sunset to sunrise, signs shall be modulated so that the brightness does not exceed 500 nits. 2, the time of sunset to sunrise shall be established by the Miami Office of the National Weather Service. 3, the sign must have ambient light monitors to automatically adjust the brightness level of the sign based upon the ambient lighting conditions. 4, the maximum increase to ambient lighting shall be less than 0.3 foot candles at 250 feet from the sign. Then 3, adult content prohibited. Adult content, including adult entertainment, as those terms are defined in ordinance number 13114, the zoning ordinance of the City of Miami as amended Miami 21, or any successor zoning ordinance, is prohibited from being displayed on signs in any manner, including messages and or images. That is the extent of the changes.
So the compromise here is that one sign goes away, the sign is not on 24 hours a day, there are allowances to monitor the brightness of the sign, and that's what I heard. We don't want to be Central Park. We don't want these lights shining into our homes all day long. The sign will be smaller, gives Miami-Dade County, still retains authority over these signs. There's a rescission clause if they're in violation, but we give them notice and an opportunity to cure, which is done in many contracts. You have to have notice that you're in violation and you have an opportunity to cure. They even have the weather service. We even have the weather service because, like the city attorney said, we can't take away the signs that are already there. And this is addressing the issues that I heard from the community. So my colleagues can chime in on the amendment, which I believe is a compromise to what we have. Commissioner Pardo?
Well, I don't see this as a compromise amendment. I see this as a stamp of approval amendment on something that should not receive a stamp of approval, meaning the Adrian R. Center does not fall under our jurisdiction. I mean, that would be like the city of Sweetwater or Coral Gables weighing in on something that belongs to the code of the city of Miami or anyone else. So I don't think we should be addressing the Adrian Arch at all. Pam has a lease with the city of Miami. This would completely muddy those waters in terms of the leaseor and the leasee relationship. We would be weighing in a way that could affect that lease. So and that's one of the main reasons that we have been arguing to stay away from these amendments, because they muddy the waters to what is otherwise a very clean piece of legislation that does away with these boards. And if there's in the future any specific properties or any specific signs that want to come back for an ordinance, we could entertain those. But we've been deferring this, which is a clean piece of legislation that we voted in on first reading. And I think we should not defer this any longer. There is an agreement on these amendments, and we should go ahead and pass what we have as a good, clean ordinance that stops these signs.
Well, do you want to say something? Oh, go ahead.
I think that what the chair has presented is a very reasonable, thought-out compromise. That, as I'm understanding, is actually going to make it better for the residents. To compare this to a stamp of approval, and Sweetwater or Coral Gables trying to dictate in our property what we should do, I don't think those are apples to apples, oranges to oranges comparisons. The Adrian Arch Center is in the city of Miami. It's not in a foreign land. So regardless of all these concepts that the county has come up with to see how they can control zoning in our most valuable pieces of properties along the bay, we do have a say-so. But having said that, we're not given the good housekeeping sign of approval to anything here. What I'm hearing is something that is going to give more protection to residents in the area. It's going to curtail the hours. It's going to make them have to not have it as bright, etc. So I don't see what's wrong with it.
I'm sure.
Commissioner Reyes?
I want to make my position clear. See, I don't have anything against the PAM. I don't have anything against the Arts Center. As a matter of fact, I like them a lot. And I said it at the beginning when this ordinance came up. I was totally opposed. I was totally opposed because it is not the problem of the size. You see, it went. I don't know how. Personally, I don't know how those institutions fell and were. Fell for it and agree to build those enormous signs and that I even asked and I never got an analysis of illumination analysis, how it's going to affect everybody, and I never got it. And I am very consistent. I voted against that type of sign, and against the ordinance, and I voted to repeal it, and I'm going to vote again to repeal it. That has been my position. I'm very consistent, and my argument it is not because I heard people come in here support the PAM, support Arch. Yes, I support you guys, but in this case. You see, there are a lot of questions about it, and the signs are totally out of size. I mean, they are too big, and it's hurting the community also. You see, so I just want you to know, Madam Chair, I really appreciate it, that it is very commendable that you come and you try to reach an agreement. But in my opinion, you know how I felt about this since the beginning. And I'm going to keep on. I still feel about it. I said it. I don't want signs. Any LED signs along this Biscayne Boulevard. And I don't want a park is a park, and it's not. They don't need. And you go to New York, you don't find any signs in any other parks in New York. You see. And I said it from day one. I don't want downtown to become another Times Square. You see.
But we have addressed that by passing the moratorium, so we're not going to have any more signs.
But I'm not going to vote to keep this. I'm going to vote against.
Okay. So, well, I have the city attorney read my compromise. Do I have a motion to accept my compromise? Commissioner Cabello?
Can I weigh in with you?
Please.
So from my standpoint, I'm listening to the situation, and sometimes we have to make decisions here. There's going to be, always, winners and losers, right? And I know it's your district, and I like to respect other people's districts, so my district, when in turn comes for me, I think that it would be doing the correct thing for my district, and I know that's what you're doing with yours. I know that wholeheartedly. What bothers me about this whole thing, that this thing started a couple of months back, really almost a year, and I'm going to ask a question because I thought of this, the way this thing got started. I'd like to ask the Arch, and I'm pretty sure that when the Arch was going to apply for this permit with the city, I believe that the Arch, I've rented commercial properties, and if I'm going to make a major change in my shop, I have to notify the landlord if I don't own the property. And I imagine that the Arch sent a letter at some point to the county, being their the lessor, and the Arch being the lessee, that this was going to be done. And correct me if I'm wrong, because now I hear about the county letter, but at that time, the county never said, oh, wait a minute, you guys can't do that because we're, am I correct in saying this? I'm asking you, people from the Arch, can somebody enlighten me on the... And if you give me a minute, I'll tell you where I'm going, and I'll finish it. I'm asking them, I'm going to ask them.
He asked a specific question. So don't,
What's that?
don't just scream out in the audience. He asked a specific question. He is responding to his question.
I didn't ask you the question because you're not with the Arch, so you might not be able to give me the answer. But let me ask it. And
Okay.
So
no more back and forth.
So
You
that's
had
it.
an opportunity to speak during public comment.
So the question is, at the time that you guys did the permit with the city, was the county notified at that time, since the county is their landlord at the end of the day, the Arch, who you're representing, were they notified that you guys were, going to apply for this permit?
The Arch Center did communicate with the county at all times what their intent was. And I think you've seen the zoning verification letter that I drafted specifically asking the county what the forum and rules would be for the application. So yes, the county was contacted.
The county was contacted, and as far as you know, did the Arch receive any letter that the county was objecting to this?
To the best of my knowledge, no. The only thing we got was a zoning verification letter, which was just amended this week.
And therein lies my problem, okay? That these people, okay, I imagined, like he's saying, said to the county, hey, we're applying, you're our lessor, our landlord, we're doing this. The county never said anything up until now. You guys went ahead and did the application, the Arch did, and we find ourselves in this mess that we're in. Now, my question is, if this was so important to the county at the time, why at that time did the county not say to somebody, hey, stop what you're doing, we're the landlords here, we don't want you to do this, and end it there? And so this thing, I think, has gotten out of control. I thought we were going to make a compromise. I thought that we were going to grandfather the PAM, the Arch. I believe, and listen, on both sides of this, there's lobbyists on both sides. I understand this. I understand it. This gentleman right here, Manny Peregas, I want to disclose this. He helped me in my campaign, and he's a lobbyist right now for the Arch. I like to be clear, but this is the problem. I thought we were going to make a compromise. We're going to grandfather the PAM in because of what they do, the Arch because of the activities they have, and the money that they're going to generate for kids and for other programs. Okay, and then we were going to stop it there. After that, nobody could do it. Nobody can do it anymore. And then I understand further that the amendment, your amendment, this is what I've been told in English. The amendment is really because if we only do the first portion that Commissioner Bartlett is doing, then the signs are going to be there. They keep the signs. However, if there's a repair needed in the future because of a hurricane or anything, then that's where it stops with what you're doing. With your amendment, I believe they're allowed to repair. That's what I was told in the briefing yesterday.
So, and let me say again, my compromise, because what I understand is the signs have been approved. So we get one less sign because I heard we didn't want a bunch of signs because the signs have already been approved. They've already been either permitted or are in the permitting process, and our moratorium doesn't look backward. It doesn't look backward. What I heard was, I don't want this bright light shining in my house 24 hours a day. So the operators have agreed to turn it off, to lower the wattage, to have content, not all kinds of advertisement. It's going to advertise events that are happening in both venues, in addition to content-related advertisement, not gentleman club advertisement and that kind of thing. Make it a little smaller for the Arch. For me, the compromise is what I heard the community saying, because we cannot take away We can't take away the signs. City Attorney? I'm asking.
I was distracted. Could you ask the question again?
We cannot take away the signs. They already have the authority to have these signs.
Right.
And in not being able to take away the sign, the compromise is, it's not the best of all worlds, but the compromise is at least you don't have the sign going all day, all night. At least there's some consideration to how bright the sign will be, et cetera, et cetera, et cetera. So if I could have a motion and a second to...
Can I clarify on this?
The city attorney put his hands... and all I'm trying to do is... It doesn't make any sense for me or us to continue on this path if I don't have even the appetite from this commission to consider the compromise that I've proposed. And that's why I've been asking for a motion and a second.
Right.
So I have a motion. Can I have a second?
I'll make the second, but I'd like to hear what he has.
Well, absolutely. We'll still have for discussion. I think the city attorney wanted to say something, and then Commissioner Pardo.
Number one, I wanted to say that, yes, you were right about the city could, of course, order the signs taken down, but it would not be without consequence. The second thing I wanted to say is, and it's appropriate that I waited till there was a second and on your changes. We think that the changes may be substantial, and consequently, since this is on a second reading of the ordinance, if you all do wish to accept these modifications, it would have to come back for second reading again, because the title of this ordinance as drafted talks about removing the signs, and now we will be changing the ordinance to be permitting signs and adding additional regulations, and I'm just trying to make this ordinance bulletproof. And so if there is a feeling for amending it, it would be best if we clean it up, bring it back to you for a second reading, and we can do that.
So that depends on my colleagues. I have a motion and a second, and Commissioner Pardo wanted to weigh in again.
Well, there's a reason that the ARSH didn't make any comments here today. It's the wrong body. We have no jurisdiction to negotiate with the ARSH. As far as the PAM goes, I'd like to ask the city manager if we received an approval for the PAM erecting the sign.
Was there a consent signed? We can't find any consent.
So we cannot find any consent signed by us that allows the PAM to erect the sign.
Yeah, we can't find any documentation that there was an executed consent.
Okay. So in that sense, we are creating a special situation when under a lease where we are the leaseor and we have some rights, and we're essentially compromising those rights, diminishing those rights for ourselves. So, and the last thing I wanted to say is about the hurricane. These things are built to code. They're built to withstand winds of 175 miles per hour. Secondly, they're allowed to rebuild the sign. That's not it. It's a non-compliant sign, and it has to comply with use only. As you can tell, we have been living with this since January. We have read and reread and studied and restudied, and that's why I'm asking my colleagues to trust us that we have done the hard work, but more importantly, that we're representing our residents correctly, and we need to draw this line right now. I mean, that's what I would be asking you for, the same way if it were in your district and you were found in this position. I'm just asking you to, let's get this done. Let's move on.
Let me address what the city manager said. You said you can't find what?
So the question arose as to whether there was ever a consent. There was an actual document drafted, supposedly. I haven't seen it.
We have that language.
Yeah,
We have the language of the lease agreement.
Yeah, so there was a document supposedly drafted, but it was never executed.
But isn't the action that the commission took the consent? No?
Chair, if I may?
Please.
Hi, Gigi Solomon, City Attorney's Office. So arguably no, because there are different proprietary rights versus regulatory rights. And pursuant to the lease, and I'm just going to read the language directly from the lease, which is Section 16.1, Assignment and Subletting of Leased Premises. This is regarding Pam, except as specifically provided in a certain article, section 16.2 below, the museum shall not at any time during the term of this lease transfer, assign, or sublet this lease, the term or estate hereby granted, or any interest hereunder, nor enter into any license or concession agreements with respect thereto, nor permit any third party or parties other than the museum, its authorized agents, employees, invitees, and visitors to occupy the leased premise or any portion thereof without first procuring the written consent of the city, which consent may be granted, conditioned, or withheld in the sole discretion of the city. I'll continue to finish the whole provision. Any such transfer without the city's prior written consent shall be void and of no force of effect, shall not confer any interest or estate into purported transferee. So, and furthermore, it says, such lease without consent shall constitute a default under this lease and shall permit the city, at its election, to terminate this lease for purposes of the section. Any change in the status of the museum so that it shall cease to be a nonprofit shall constitute an unauthorized transfer. So the issue here is, it was the city attorney's office had received a proposed written consent for the PAM. We reviewed it. We did make some revisions and sent it to the city manager because it is the city manager that was supposed to provide written approval. And it was then confirmed from his office that no written approval executed went out. So that is the issue here. The city does have two different hats it's wearing. One is regulatory and the other is proprietary. And so it could be, perhaps, as the commissioner states, that if one action may actually be stopped the city for another, but at this time, we don't know if that is the case once we further fact find. But there appears perhaps to be a breach.
Okay, so we don't know. There's a big question mark here. So in light of that, again, I have the compromise, and it's the will of this body. If you want to accept the compromise proposed, or if you want to move forward, we had a motion and a second to accept my compromise. All in favor?
Chair, the title.
Oh, I'm sorry. It's a second reading item, and the title needs to be read into the record.
An ordinance of the Miami City Commission amending Chapter 2, Article 9, Section 2-779 of the Code of the City of Miami, Florida, is amended, titled Administration, City-Owned Property, Outdoor Advertising Signs, and On-Site Signage on Government-Owned Property, to amend Ordinance 14140 to bring it more into conformity with prior Ordinance 13536, so as to disallow LED signage and other recent changes containing a severability clause providing for an effective date.
So I had a motion and a second for my compromise. All in favor?
Aye.
Aye. All against?
No.
So motion carries 3-2,
3-2 with Commissioner Reyes and Commissioner Pardo voting no as amended.
as amended. Mr. City Attorney, would you please read SR2, the title, for the record?
Yes, Madam Chair. SR2, an ordinance of the Miami City Commission amending Chapter 10, Article 6, Section 10-101 of the Code of the City of Miami, Florida, as amended, titled Buildings, Unsafe Structures, and Unsafe Structures Panels, specifically by amending Section 10-101L, titled Unsafe Structures Panels. Unsafe Structures Panels are hereby created to conduct hearings as provided for under this section, to amend qualifications for members of the Unsafe Structures Panel, containing a severability clause and providing for an immediate effective date.
Do I have a motion? Do I have a second?
Second.
I have a motion and a second for SR2. All in favor?
Aye.
Aye. Motion carries unanimously. Mr. City Attorney, would you please read into the record the titles for first reading ordinances?
That'll be FR2 and FR3.
Correct.
FR2.
FR1 has been deferred.
Yes, ma'am. FR2, an ordinance of the Miami City Commission amending Chapter 2, Article 4, Division 2, Section 2-208 of the Code of the City of Miami, Florida, as amended, titled Administration, Departments, Planning, Building, and Zoning Department, New Permits Prohibited, Non-Homestead Properties, to provide the allowance for issuance of certificates of use for businesses unless there is a violation of the building department. Further amending Section 2-211 titled Denial or Revocation of Certificate of Use by limiting restrictions for denial or revocation of a certificate of use containing a severability clause and providing for an effective date. FR 3, an ordinance of the Miami City Commission amending Chapter 2, Article 3 of the Code of the City of Miami, Florida as amended, titled Administration Officers by creating new division, Section 2-160, to create the Office of Inspector General, providing minimum qualifications, appointment and term of office, providing the functions, authority, and powers, providing for administrative staff, providing a procedure for finalization of reports, and recommendations containing a severability clause, and providing for an effective date.
I have a motion. Do I have a second?
Second.
I have a motion
Discussion.
for discussion. Commissioner?
In FR2, Mr. City Attorney,
Yes, sir.
can you explain this to me clear so that I could understand it better?
FR 2, you're asking?
Yes,
sir.
please.
Sorry. And there was a substitution distributed.
I haven't seen that.
Do we have the substitution? Hold on.
No. I don't believe the substitution was Friday, was it?
So, can I, with the chair?
Yeah. No, that's fine.
ahead.
Go
Go
ahead.
ahead.
While he's getting his stuff together.
Yeah, I was just going to give you a little rundown.
Yeah.
I'm the one that's presenting the thing, and my thought was, we've been having problems, people coming, constituents coming to my office, and these regulations that we have caused a lot of stuff, they wreak havoc, really. We got together with building and other departments to see how we can pick the lesser of the two evils, shall we say. Because there was a lot of stuff going on with demolition and stuff for stuff that really shouldn't have been that. And it's merely changing the wording and give more leeway, but with guidelines, with guardrails. On the, for example, instead of permits may not be issued for a we're changing the wording to give the, in cases where the properties are going to be demolished, to give the authorities more leeway in making sure that we go through all the avenues before we actually demolish a building.
Now,
All right, ready? So let me sort of walk you through it, Commissioner, or Vice
thank you,
Chair.
Commissioner.
All right, so there's two changes. One is to 2-208. That's the new permits prohibited. Previously, it said permits shall not be issued by a non-homestead property with any outstanding code enforcement violations, building department violations, or any relevant city lien or invoice due and owing to the city. That's being changed to read, permits may not be issued for a non-homestead property with any, they're striking out code enforcement violations, leaving building department violations, and then striking out the or any relevant city lien or invoice due and owing to the city.
Okay, hold
Adding-
on. So you're striking out code enforcement violations.
Yes, sir.
I mean, is that going to be left or taken out?
Code enforcement is going to be taken out, building department violations. So this will only apply to building department violations. So
Okay, so this new ordinance, code enforcement violations will stay.
yes,
The other violations will remain.
right.
So it's only for building violations.
Building violations. Now, the language of or any relevant city lien or invoice due and owing to the city is being moved from 2-208 down to the certificate of use. So that section previously said the zoning administrator shall deny the issuance or renewal of a CU for good cause when there are any for good cause. Now it'll say shall deny the issuance or renewal of a certificate of use when there are any outstanding city liens or invoices due and owing. So the city will capture them at the time of CU if they owe money.
Okay, now, let's see if we can find an area that accomplished what you stated you want to accomplish, Commissioner Govella.
Yes, sir.
Can we include language in here that will separate the normal person that you're concerned about from habitual offenders?
That's fine with me. What I'm trying to accomplish is.
I think
that-
I understood.
Yeah,
I think I
so in
understood.
other words, we try to enforce these things, but also we create the problem where people don't want to come in because they're scared of us, right? Because they're going to get into, from one trouble, it's going to go to another. So then there's no compliance really, because people are not coming in and that's what we're trying
Your
to.
point is well taken. What my concern is, and I think it was a major concern before when this change was made originally, that you don't have like the people that we heard from on the parking, that we were very kind to them and only charged them the $300,000, that you don't have people like that take advantage of the system, that might be connected, and are habitual offenders, that we're leaving them a way out. I think that if we could put a clause in here, and Mr. City Attorney, help us on this, that will say that unless you're a habitual offender, and I also would like to hear from our zoning director in some of this, and our.
By the way, Commissioner Carrillo, this is done in consultation with our building departments, and we worked on the language, and
I appreciate it. I just want to get their statements on the record for transparency's sake, so it's there for the future, what they said. But how can we make an amendment in this that we accomplish what Commissioner Gavella is stating, but at the same time, we do not let habitual offenders sneak through?
So, first thing, and I assume you're talking about habitual code enforcement violators, right?
Code or building,
Right.
which, I guess goes hands in hands.
Yeah, so the building violations would be caught up, but so for code, we would just have to change it to say with any outstanding code violations, and then quantify that as far as like, or has been deemed a habitual offender or something
I
to that
guess in
effect.
code, you're leaving it as before. It's not being changed. So that guarantee is still there, correct?
Well, let me just be clear. So this ordinance strikes out code enforcement violations. So when somebody comes to the building department to apply for a permit, if they have any outstanding code violations now, they will not be able to pull the permit. After the effective date of this ordinance, they will be able to pull a permit. What they won't be able to pull a permit for is if they have an outstanding building violation.
Okay, well, what I'd like is on both code and building that we put that guarantee that if you're a habitual offender, and that doesn't mean that is, as we know, habitual offender, that X company has only got this property, and then you got 10 companies owned by the same individuals that have different names. It has to do with the ownership, if it's the same type of ownership. That's the habitual offender. So if we could get some language on both of those, that would give us that guarantee on habitual offenders.
We could do that.
Yeah, Commissioner Carrillo, what I was trying to, that Frank was reminding me, because we had these extensive conversations with the building and others, is that what we're trying to do is, we're trying to, for people to come in voluntarily so the unsafe conditions are not created, because the problem is people are not coming in and we have to go after them because of our draconian sometimes. You get the picture.
I understand
and
what
I
you're
understand
saying.
what you're saying with the serial,
Yeah.
I understand that.
And I'm going forward with you in that. The only separation that I'm making, look, for the average person that, they made a mistake one time, they got to resolve it, I'm going along with you. What I'm asking to be added is the amendment on code violations and building violations. If these are habitual violators that have been playing the system, that
they do not pass go, they do not collect 200. That we stop those people. And I think this will resolve the problem for 98%
Madam Chair?
of the individuals.
Can I hear, excuse me.
Madam Chair? Could you hold on a second?
Commissioner Reyes?
I do understand what you want to say, Commissioner Carollo, but how can we identify the habitual?
That's where I was going.
Habitual offender, and the only way that we can do that it is, in my opinion, place an amendment that individuals that they have more than one property in violation, then they require different treatment, right? Because how can we identify the habitual offender? You see, I could do it in one building, and then when I cure that, I buy another building, and I don't do anything until I'm caught. You see, how can we?
Very simple. All they got to do is run the names of the registered agent and or the managing partners in the LLCs or company through Sunbiz, and they will see what other properties they've owned, and the city could see if those properties have had those problems. It's fairly easy.
That's what I'm saying. You check if that individual, whoever comes in, has another property. You see, that also has.
Yeah, but we would verify with the Sunbiz. I mean, look, if you got an LLC or a corporation, I have an LLC corporation, so, the point is, now you can't do it in Delaware. In Delaware, you got to pay money, and that's why people go to Delaware, because if you really find out, it's going to cost you money to find out who that individual is behind whatever. But here in Florida, you can find out. But you know what? I mean, who invented like the saying goes, who invented the law invented the way up. It ain't going to be perfect. I'm just trying to find the lesser of the two evils, because I've had constituents in my office that they were about to be demolished for something, what I call stupid, okay? And at the end of the day, we were able to save those and you can talk to Ace about this, that it happened. I've had 2 individuals already because of this problem that we're having with the wording. That's what I'm trying to accomplish. I'm not saying.
But I think by this, we will protect 98, if not 99%, of the people that you are trying to protect, and it won't apply to 98, 99% of those people. It's just that 1% or a little more than 1% that has been taking advantage of the system. Now, we have different ways of looking at that. If I, Chair, through the manager, ask the assistant manager and former building director if he could let us know how we've done this in building in the past with habitual offenders.
Commissioner, good afternoon. Ace
Good
Valera.
afternoon.
I just wanted to point out that if we, Sunbiz does not link today with any of our permitting systems. So this, if we're going to check for every company with the sheer volume of permits that we issue on an annual basis, which is close to 30,000 permits, I mean, that would be a very labor intensive. We can definitely, everybody that has a current violation with the unsafe structures, we can definitely track those. If the name doesn't change, right, that particular entity, we can very easily keep track of that entity and make sure that that entity is, if it is a repeat offender, is kept in check going forward. What other sister agencies or companies that particular entity may have is very difficult to track, because that would be a manual process. But the entity itself that committed a repeat offender, we can definitely track that one going forward. If it's limited just to that particular entity and ensure that a repeat offender can be applied.
In that entity, you have names, registered agent, you have individuals. You can do the same thing through your system that you have by putting those names and seeing what other companies come up.
We can, but that would be a manual. I just wanted to make sure that we understand that will be a manual process, and we have approximately in the neighborhood of 6,000 to 7,000 violations in the on-site structures department right now. So that would be making that consistent check every time we get to that level. So that at least we know what the expectations are.
We can't sacrifice 90% of the people for 10% that's doing and I understand
Not
what
even
you're saying.
10%.
Whatever the number is, is what I'm trying to say here.
But my question is, what process have we been following with habitual offenders now in the city?
In building, we don't have right now that repeat offender ordinance. That would be only in code. So that's not in building today.
I think we can, for me, this is a start to helping correct a situation, and we can continue to look at it and add when staff has figured out how to do that. But at least this gives some relief and provides a path forward.
So we could definitely contemplate for the entity that is in violation, and that entity becomes a repeat offender. We can definitely apply it to that entity going forward. I just want to, in that particular instance, Commissioner, and as perhaps our permitting systems in the future could integrate better with iBuild, that could be something that we can definitely contemplate. But in the interim, I think at least those entities that have, that are repeat offenders, without going into the level of research of what other.
Could you,
Commissioner Reyes?
through the chair, could you, between first reading and second reading, just come up with some sort of?
We can definitely advise on that level. Absolutely.
Let me see if this would make sense. We go forward in the amendment with what you're saying on a particular entity. That you could check to see if they're a repeated offender or not.
That we can do.
And if they are a repeated offender, and if you find out at any point that they are a repeated offender with any other entities that they own, we're not ordering you then to look, but if you find out.
Are you okay with this? Okay, so we're going, I have a motion and a second for first reading.
Yes, motion.
Did you understand what I said?
Yes, I know.
We're going to go with what he said.
Okay.
On the one firm, let's say that is X LLC that's applying, they could check X LLC by itself to see if they have been a repeated offender.
So if you're an LLC, you're going to be the managing member, or you're going to be members. If you're a corporation, you're going to be the president, the vice president, the treasurer, blah blah blah. But here's the point. That's fine. That's fine. So we do the first reading and then let him work for the second reading, and that's good.
So I have a motion and a second. All in favor?
And so,
Aye.
Chair,
As amended.
FR2 as amended.
FR2
And
as,
FR3 as is.
and FR3 as is.
Could I just make a note on FR3 that
Yes.
that is the, I believe, the Independent Inspector General, which we can't bring back until after the voters have decided.
I was going to thank you because I was going to offer that. I'm going to ask for that we don't bring the second reading until after the election and people have decided if they want it or not.
Right. Thank you, Commissioner.
And Madam Chair, just for the record, I wanted to add that I will not be at the May 9th meeting. I think all the offices have been informed, but I want to make sure that that's on the record. When will SR1 come back?
We could make it in the next meeting when you're here.
Right. And
Okay,
anything,
just-
and any item that you want to be deferred, we do that as a courtesy because you won't be here.
So for noticing purposes, May 23rd will be the earliest to bring back SR1.
Okay.
So you'll be here.
Thank you very much.
Okay. Discussion items. Are there any discussion items that my colleague would like to defer today?
How about this BU? Okay, we did
We
already.
did BU.
D1, no.
Anybody? Okay.
2, 3. Hold on, let me just look at them. Okay, we're going to start taking it one by one, or?
DI1, review educational uses ordinance. Review educational uses ordinance.
Good afternoon, Madam Chair, members of the Commission. Daniel Goldberg, Zoning Administrator. DI1 is discussion item related to an ordinance adopted by this Commission in June of last year to permit educational uses to proceed by right in the urban core without needing an exception or warrant. There was a requirement that it come back to this Commission as a discussion item to give you a status update at this time. At this time, there is one applicant we are aware of that has availed themselves of this program, and that is Key Point Academy at 1501 Biscayne Boulevard. They are currently in process. They haven't completed it, but we are aware of one applicant for this item, for this ordinance. This ordinance does sunset July 3rd of this year, so if the Commission's will to continue it on a permanent basis, a directive to that effect would be appreciated, and I'm available for any questions you may have.
Does anyone have any questions?
I'm ready to make a motion. I heard I was brief, so I know what it is.
Do we require a motion? No, it's just a discussion item. It doesn't require a motion.
Oh, okay.
Okay. Thank you.
Well, but for purpose of clarity, it requires some direction. So it doesn't require a reso, but it would be great for Dan to get some direction in terms of whether we continue to bring this back as a permanent program, continue it as a pilot. You can probably do that as well. But it really requires some feedback. I mean, we need to kind of know where to take this. Do we bring it back again?
I'd say pilot.
Directed.
The only thing is the code says we can only have a 2-year, 1 year, extend 1 year.
That's what I'm saying. Yeah, so
Okay.
we would
And it's
extend the
only
pilot
gonna
one more
affect
year.
1 year, right?
Or
in July.
Or we bring it back as permanent legislation, or we end it altogether. I mean, we could. Those are really the three options.
What would be your recommendation? How do you feel like this achieved the goals, the objective?
I would defer to my colleagues in planning, but the reason that you have the requirements for entitlement for schools, that schools can have an impact on neighborhoods. However, this is the urban core, your greatest mix of uses, your most intense uses. I haven't heard any complaints, but again, we've only had one applicant.
Absolutely.
And that one applicant hasn't completed the process. I think there's definitely some, would be beneficial to keep it if that's the Commission's will.
I believe so as well.
Extend it for one more
So
year.
let's extend it for another year to see. That would be the least over. Extend it for another year, see how that goes, and then we can make a more permanent decision.
Yes, ma'am.
Do I have a motion? Well, do I have a motion to give the city that directive to extend the
I'll
program?
make the motion.
I have a motion. I have a second. All in favor?
Aye.
Motion carries.
Thank you.
DI2, charter review process.
Of the Director of Procurement?
Good afternoon.
Good afternoon, Chairwoman, Commissioners. Annie Perez, Director of Procurement. So we were tasked, I think it was back in January, to do some market research about charter review kind of best practices and what other agencies are doing. So we have done a comparison of 6 agencies, and I also added the City of Miami as a comparison. So get started. So we'll start with the City of Miami. It was done, it was a Charter Review and Reform Committee. It was comprised of 20 members, and it was an advisory committee. It was called the Charter Review and Reform Committee. So the final report was submitted June 8th, 2016. There were 17 recommendations. 5 were sent to referendum. Of the 5, actually 3 were passed by the voters. This is a mistake. It was 3. The second one we have is Miami-Dade County. It was done in 2017. They have 15 committee members. They call it the Charter Review Task Force. It was advisory, and the final report was submitted February 28, 2018. There were 8 final recommendations that were approved for amendment to the charter, 8 recommendations, and 5 made it to the ballot. And also in both the City of Miami and Miami-Dade County, they did not use a consultant. So Broward County, so the interesting thing about Broward County is that they are the only ones out of all the ones that we looked at that the type of committee is executive and not advisory, which means that their recommendations, the Charter Review Commission's recommendations, go straight to referendum. And they have 19 members. 11 amendments were submitted for voter approval on November 6, 2018. And there was no consultant utilized.
Did all of them pass?
That we don't know because we tried to call Broward County multiple times and we weren't able to get an answer. So,
Thank you.
No problem. So Orange County, their process started in 2023 and it's still going on. They have 15 members. They have a Charter Review Commission. They are advisory. Again, we don't know how successful it was because the CRC is still ongoing and they did not use a consultant. Seminole County, similar to Orange County, they started in 2023 and they're still doing their charter review. There's a Charter Review Commission. There's 15 members. It is advisory and no consultant was utilized. City of Jacksonville, they did it in 2020. There's 15 members. They have a Charter Review Commission. Again, they were advisory. The final report was submitted May 29th of 2020. All measures were recommended by the CRC, failed at City Council, or were changed via referendum. And no consultant was utilized. City of Fort Myers, again, they were 2023 to now. They're still working on it. There's 9 Charter Review Advisory Board members. They are advisory. The board is ongoing. Recommendations are being sent to the City Council for approval to place on the ballot. All changes to the charter must be done through the referendum process, and no consultant was utilized. And that is it.
Thank you.
Thank you. We've been working closely also with the mayor's office. And one of the things I asked a lot about is when we look at these structures, let's look at the recommendations and how many actually were adopted. City of Miami, 18% of what was recommended actually made it to be adopted. The last thing we want to do is waste the time of people that are, serving in these committees in these capacities. So we will come back, maybe the 23rd, maybe later, with this.
Okay. All right. Thank you. DI3.
That's, sorry. I'm the one hosting that. I'm going to go ahead and defer that to the next time.
Okay. May I have a motion to defer DI3?
Motion to defer.
To the, which meeting? Because Commissioner Cabello.
Next meeting.
Commissioner Pardo's not going to be here for the next meeting, which is May
9th.
9th.
Yeah, the 9th.
Okay, so the following.
The second meeting in May.
May 23rd.
I have a motion and a second. All in favor?
Aye.
Okay. DI4.
DI4 is campaign finance reform, and I thought the city attorney could help enlighten on the issue.
Right, and correct me if I'm wrong, Commissioner, you were interested in adopting provisions similar to the Miami Beach Code, right? So,
Correct.
The Miami Beach Code provides 2-487 of the Miami Beach Code, prohibited campaign contributions by vendors. It's not all vendors per se, but it's no vendor shall give a campaign contribution when they have a pending contract, standing order, direct payment. So no vendor, active vendors can give campaign contributions. The next section is contributions by lobbyists on procurement issues. No lobbyist on a present or pending solicitation for goods, equipment, or services may give campaign contributions, and a candidate may not accept such campaign contributions. 2-489 of the Beach Code says prohibited campaign contributions by real estate developers, and they have a definition for what a real estate developer is. Then 2-490 of the Beach Code says prohibited campaign contributions by lobbyists on real estate development issues. And so that relates to no lobbyist on a pending application for a development agreement with the city or application for change of zoning map designation shall solicit for or give a campaign contribution directly or indirectly to a candidate. And then 2-491 is the final one of the Beach Code. No campaign consultant shall lobby the city commission for a period of 12 months following the swearing in of any elected official for whom the campaign consultant provided campaign consulting services within the past election cycle. So those are the categories covered by the Beach Ordinance.
And there would be a fine, $500 for any violation. That's pretty much how it goes. So
Question.
can we go back and I'm sorry?
No, Commissioner Reyes had a question, but if,
When you are saying a campaign contribution, you are saying you're forbidding, or you don't, you're asking for the contributions for the campaign. How about PACs? Because you can very well circumvent that.
It doesn't cover PACs, and we know.
You know what I mean. You know
Yeah.
what I'm heading to.
Right. I totally know.
We are not doing anything if you cannot cover PACs. It's just
Right.
it's just limiting campaign contribution to 500. I've been there, done that before. I was in a committee before a long time ago about campaign contribution. And if you limit it to $100, any contributor that want to give you $1,000, find 10 people that is going to give $100 to. You see, that is it. There is always a way to circumvent them. You see, unless the only way that we can level the playing field is by restricting, and I don't know if it is legal, if it is constitutional, it is restricting the expenditure. That's the only way. And how do you do that? That's because otherwise, you see, in my opinion, they had always been circumvented. Always.
you're recognized.
Yes, sir.
I think we're getting here with PACs into an area that the U.S. Supreme Court has spoken very loudly on, and not in a way that maybe I agree with it, because I think it's changed from the White House to the courthouse, the way things are done. But the question to you is there anything that could be done with PACs based upon the Supreme Court ruling?
Right. Let me.
You don't have to answer now if you're not fully appraised.
Yes,
to
thank
bring
you.
it back. I mean, I don't want
Thank
to
you.
put you on your first day.
Thank you, sir.
On the guillotine.
Yeah, that's a very complicated question, and we'll be more than happy to look into it and come back to you on the lobbyist, on these prohibitions, because the beach passes some ordinances that I sometimes feel are unconstitutional. But we will look into these, because essentially what the competing issue is First Amendment speech rights. You know, the Supreme Court has said that certain campaign contributions are considered a form of speech. So we will look at that. And we'll also look at it as far as the PACs and give you guidance on that.
And really our main concern is where there's a conflict, an obvious conflict with doing business with the city. But yeah, we're going to look at all of that and definitely come back.
Well, let me say this, so no one's surprised later on. What I would be looking to do is to put a charter amendment. The earliest we're going to be able to do it will be November election, but to put a charter amendment on the November election on whatever we come to an agreement on, so that it just can't get changed easily into the future. And this is why I want to be given Mr. City Attorney copies of whatever the beach has, be able to read it, see what else I might want to add to it. For instance, what Commissioner Reyes was saying in, people, how they go around. Back in 2020, there were some nice chaps that wanted to recall me. Basically, none of them lived in the city. What happened? Well, to my surprise, I found out sometime later that the PAC that was running the recall committee bought some advertising, TV, radio, small amounts. I think it was around 17,000, somewhere in there. They actually did buy it. They actually did spend it through the PAC correctly. However, in one radio station that I have the proof already, I'm hoping that I soon will get the proof on the second. The PAC bought another 50,000 plus worth of advertising. The entity that placed the advertising for the PAC was a company that its owner had been arrested a few years before for some naughty stuff with the federal government. Dealing with Panama and forging the names of federal agents and stamps and so on. But the biggest surprise to me was that the PAC never paid for those advertisements. The PAC was the one that bought the time under his name. It was aired for the PAC. The PAC never had the money in his bank account to pay with. So there were two separate corporations from two private individuals that actually bought, or should I say, that actually paid for the advertisements. I think with the guy that used to sit where you're at, Mr. Gavella, they called it money laundering. I read in today's newspaper that those two fine individuals from those two companies, they're now going to run the campaign of someone running for sheriff. Ain't that wonderful? Only in America.
Okay, moving along. Mr. City Attorney, would you please read into the record the titles of the PZ items for consideration?
Yes, Madam Chair. I believe the first one I have is PZ4,
How about mine?
which is a resolution, doesn't need to be read into the record. PZ6, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 is amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to section 163.3187 Florida statutes by changing the future land use designation from medium-density restricted commercial to restricted commercial of the acreage described herein of real property located at approximately 775 Southwest 8th Street, northwest portion, 750 Southwest 7th Street, and 740 Southwest 7th Street, Miami, Florida, is more particularly described in Exhibit A, attached and incorporated, making findings containing a severability clause and providing for an effective date. PZ7, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, by changing the zoning classification from T5L, Urban Center Transect Zone, limited to T680, Urban Core Transect Zone, open of the property located generally at 775 Southwest 8th Street, northwest portion, 750 Southwest 7th Street,
and 740 Southwest 7th Street, Miami, Florida, as more particularly described in Exhibit A, making findings, containing a severability clause, and providing for an effective date. PZ 8, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to 163.3187 Florida statutes by changing the future land use designation from duplex residential to low-density restricted commercial of the acreage described herein of real property at 200 Northwest 42 Avenue, western portion, and 4212 Northwest 2 Terrace, western portion, Miami, Florida, more particularly described in Exhibit A, attached and incorporated, making findings and providing for an effective date. PZ 9, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended Miami 21 Code by changing the zoning classification from T30 Suburban Transect Zone open to T40 General Urban Transect Zone open for the western portion of the properties generally located at 4212 Northwest 2 Terrace and 200 Northwest 42 Avenue, Miami, Florida, more particularly described in Exhibit A, attached and incorporated, making findings, containing a severability clause and providing for an effective date. PZ 10, an ordinance of the Miami City Commission with attachments amending the future land use map of ordinance number 10544 as amended the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to Section 163.3187 Florida statutes by changing the future land use designation from medium-density restricted commercial to restricted commercial of the acreage described herein of real property at 860, 862, 842, 834, and 826 Northwest 1 Street, and 821 West Flagler Street, Miami, Florida, as more particularly described in Exhibit A, making findings and providing for an effective date. Just want to make sure I said 852. PZ 11, an ordinance of the Miami City Commission with attachments amending the zoning ordinance of the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended Miami 21 Code by changing the zoning classification from T50 Urban Center Transect Zone open to T680 Urban Core Transect Zone open for the properties located 860, 852, 842, 834, and 826 Northwest 1st Street, and from T50 Urban Center Transect Zone open to T680 Urban Core Transect Zone open for the northern 45 feet of the property located at 821 West Flagler Street, Miami, Florida, all as more particularly described in Exhibit A, attached and incorporated further, recommending to the City Commission acceptance of the voluntarily proffered covenant, attached and incorporated as Exhibit B, making findings, containing a severability clause, and providing for an effective date. PZ 12, an ordinance of the Miami City Commission with attachments amending the future land use map of ordinance number 10544 as amended the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to Section 163.3187 Florida statutes by changing the future land use designation from low-density restricted commercial to restricted commercial of approximately 2.54 acres described herein of real property at 460 Northwest 36 Court, East portion, 427 Northwest 37 Avenue, East portion, 400 Northwest 36 Court, 408 Northwest 36 Court, and 440 Northwest 36 Court, 146 Northwest 36 Court, 140 Northwest 36 Court, 114 Northwest 36 Court, 100 Northwest 36 Court, 102 Northwest 36 Court, 70 Northwest 36 Court, 64 Northwest 36 Court, 58 Northwest 36 Court, 3667 Northwest Flagler Terrace, and 3695 West Flagler Street, Northwest portion, Miami, Florida, Assemblage A. And by changing the future land use designation from duplex residential to restricted commercial of approximately 0.34 acres described herein of real property at 697 Northwest 37 Avenue, Southwest portion, 640 Northwest 36 Court, South portion, and 3665 Northwest 6th Street, Miami, Florida, Assemblage B, collectively the assemblage, all as more particularly described in Exhibit A, attached and incorporated, making findings, containing a severability clause, and providing for an effective date. PZ 13, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended Miami 21 Code by changing the zoning classification from T680
Urban Core Transect Zone open to T680 Urban Core Transect Zone open for the property generally located at 697 Northwest 37th Avenue, north and southwest portion, and by changing the zoning classification from T4L, General Urban Transect Zone Limited, to T50 Urban Center Transect Zone open for the properties generally located at 697 Northwest 37th Avenue, southeast portion, 640 Northwest 36th Court, south portion, 3665 Northwest 6th Street, 460 Northwest 36th Court, east portion, 427 Northwest 37th Avenue, east portion, and 400 Northwest 36th Court, 408 Northwest 36th Court, 440 Northwest 36th Court, 146 Northwest 36th Court, 140 Northwest 36th Court, 114 Northwest 36th Court, 100 Northwest 36th Court, 102 Northwest 36th Court to Northwest 36th Court, 64 Northwest 36th Court, 70 Northwest 36th Court, 58 Northwest 36th Court, 3667 Northwest Flagler Terrace, and 3695 West Flagler Street, northeast portion, Miami, Florida, all as more particularly described in Exhibit A, attached and incorporated, making findings containing a severability clause and providing for an effective date. PZ 14, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to 163-3187 Florida statutes by changing the future land use designation from duplex residential to public parks, real property, to public parks and recreation of the acreage described herein of real property at 1320 Southwest 21st Street, Miami, Florida, as more particularly described in Exhibit A, attached and incorporated, making findings and providing for an effective date. PZ 15, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended Miami 21 Code by changing the zoning classification from T30 Suburban Transect Zone Open to CS Civic Space Zone of the property generally located at 1320 Southwest 21st Street, Miami, Florida, as more particularly described in Exhibit A, attached and incorporated, making findings containing a severability clause and providing for an effective date. And I believe that's it. The next two are first reading ordinances which don't have to be read.
City Clerk, just for the record, PZ 16 and 17, I have Jennings disclosures while we wait.
Okay. Just sit back and wait for the chair.
Mm-hmm. It's for the clerk.
Okay. PC 16 is in your district, Mr.
No, it's not in my district.
That is not. Yeah, I know what it is. It is, I think, District 1, 5 now.
Sorry, let me, I need to read two more titles. Rookie mistake. PZ 16, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to section 163-3187 Florida statutes by changing the future land use designation from duplex residential to low-density restricted commercial of the acreage described herein of real properties located at 1300 Northwest 38th Street and 1317 Northwest 37th Street, Miami, Florida, is more particularly described in Exhibit A, making findings containing a severability clause and providing for an effective date. PZ 17, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, is amended Miami 21 Code by changing the zoning classification from T30 Suburban Transect Zone to T4L General Urban Transect Zone Limited of the properties generally located at 1300 Northwest 38th Street and 1317 Northwest 37th Street, more particularly described in Exhibit A, making findings containing a severability clause and providing for an effective date. Thank you.
Mr. City Attorney?
Sir, yes, sir.
Do we need to have public hearing for PC, or was it sufficient that we had it earlier?
We had it earlier, yes, sir.
Okay, so we don't need any further public hearings. Is there a motion on these items?
I'd like the motion, if I may.
Excuse me?
I'd like to ask the attorney on my item 1300 Northwest 38th Street and 1317 Northwest 37th Street. We're going to the next upzoning on that one, right, from duplex. But can we put a covenant in there, or possibly can we do that whole block for future? Because I was talking to some of the residents, they were concerned. The owners of this property actually came to me and said that they're not interested in building the higher zoning that we're giving them. Is David?
Right. PZ 16 and 17 is currently requesting that upzone from T30 to T4. We can go back and study the block as a whole to see what that zoning designation should be as you know, the neighborhood as a whole, if that's the will of the commission in your district.
I'd like to go ahead and do now, if possible, the 16 and 17, but having that in mind that we do the rest of it so it becomes conformity to
uniformity. Yeah.
Yeah. Because we've looked at the area, and we think the area merits it.
Right. We can come back if that's, you know, with the study, work with your office, however you wish. But yeah, we can look at it for sure.
Commissioner Reyes?
Does PC 16, that area, that about T3s?
Correct. So yeah, the zoning designation in that area is T30.
And then
currently,
what you're doing is you are just changing that area to what?
so the request for the particular parcel is to go from T30 to T4L.
That is a 4-story.
It allows 3 stories.
And it's going to be in the middle of, what you're doing. You see, one thing that I always want to do is protect T3s, because we will destroy it all in the neighborhoods if we can start changing. And as a matter of fact, Miami 21 also tries by all means to have some sort of protection for T3s, and also gradual increase. But this one is not going to be a gradual increase.
Right. So I think it sounds like the request or the directive is to go back and look at this neighborhood to look at what is the appropriate zoning for that area.
I would like for you to do that.
But what I was going to say is, you know, they're abutted on the north. They have the 112 highway. On the other side, they have the T6, is it, that they have on the other side? On 36th Street. So they're surrounded. And then you have the other problem that what happened was that the owner of this property, she's not interested in going to the maximum thing. She was willing to make a profit. Okay, but she doesn't want to get out of the circumstance she's in, because she says she rents it out and it becomes a boarding house that they start subletting, and then that's bad for the neighborhood.
It is good.
And that's where this is coming from. And I've spoken to her 2 times, and she's sincere. She's not interested in making the full use of you know. She'd like to see a townhouse. You know, she's not going to go 3 floors. She's even willing to proffer that. If that's, you know, if that would be a problem.
Well, what are we going to do? We're going to look into it and come back? Okay,
Yes.
then we have to
Yes.
defer them. Okay. Then we have to be deferred, right?
Madam Chair, it seemed like there was a Jennings disclosure by Commissioner Pardo already made one. I believe Mr. Gabella just sort of made his Jennings disclosure. And District 4, you indicated, Commissioner Reyes, that you wanted to make a Jennings disclosure on 16 and 17 as well.
That's right.
Thank you.
Can I just say that I'd like to do this today, and maybe proper that they're going to do not the 4. What were the 3 stories you said the maximum?
Right. T4 allows 3 stories.
3 stories only.
how long would your study take?
I would give us probably at least a month to come back.
Yeah, let's do that, Commissioner, and let's analyze it. I mean, we have, I think that Ms. Sommer was here. She was totally opposed to that. And she's been living there forever. I've known her since.
Well, I'd like to, when I can, I'd like to, let you guys do what you do in your districts, because I think you guys know best. I think I know best in my district.
Sir, with all due respect,
Yeah.
there is no fiefdom here. We are all.
No, I'm not talking about a fiefdom. I'm talking about what I'm talking about. That I believe that I know my area better than you know my area.
Well,
just like I don't know your
the city
area
of Miami
like
back
you
and
do.
forth
That's
from
what I'm
one
saying.
to the other. And so
No
do you.
fiefdom, no fiefdom. It's just
don't,
that.
Don't start with that. That's my district and all that. No, you are City of Miami Commissioner. You're welcome to get in my district.
Not interested. I'm interested in working for my zone and for the whole of the city of Miami.
Well-
But what I'm saying is, I don't think you know my area better than I do. Just like
Okay,
I
well, let
don't
me
know
tell you
your
this.
area better than
Let me
you
do
do.
this,
That's all I'm
Mr.
saying.
Gabela, I'm not trying to
No,
interfere.
no.
The only thing that I'm trying to do is protect the neighborhoods, protect T3s and protect the neighborhoods, single-family homes. I don't care if they are in Timbuktu. You see, I'm going to do that. I'm going to try to protect it. That's what I've been doing.
Well, I'll tell
If
you what.
have
Let's do
followed
this.
me, I've been doing
I got
this
an
all
idea.
over.
I got an idea. Then let's put all these PZs, because to be honest with you, I haven't had a chance to study the rest of them, including the ones in your neighborhood.
Okay, go right
And
ahead
let's
and
do
do
that. Let's go ahead and defer all this, and then we'll do it the next time.
Go for it.
Who's in first, who's in second?
That's right.
I'm sorry, I had to step away to do a love letter to Haiti. It's a video, so I'm not clear what's happening right now.
Okay.
I don't know what item are we discussing?
We're just going PC 16.
So PZ 16, okay.
And
I
17.
understand.
PZ 16 and 17.
16 and 17. So do I understand, is there a motion to defer all of the PZ items?
Motion.
No, you want it?
Look, you got people
We
here
cannot act
that,
like children here, you know.
we have people here that
We cannot.
have spent their time, their money to be here.
That's right.
Look, Commissioner Gavela,
Yes, sir.
I'm willing to pass this on first reading ordinance until it's clear for second reading.
It's the first reading.
But, I think we need to move with the agenda.
I
So-
understand that, and I don't want to hamper anybody, but you got to understand, this lady has been in my office 2 times. She also has been waiting for this, and she makes the case that she doesn't want boarding, and then that's not good for the neighborhood, and this lady's sincere. Let me tell you, if not, I want to be doing it, okay? And I know my area. That's what I'm trying to do. So the same thing, that goes for you guys goes for my.
So it's a first reading item, 16 and 17. Are there any other PZ items that my colleagues would like to pull for discussion? No? Okay, so may I have a motion to pass PZ 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17?
Through the chair, please. I need to put something on the record. For PZ 10 and 11, the city attorney has asked me. Thank you, sorry. Melissa Tapinas, 200 South Biscayne Boulevard, Miami, representing the applicant in PZ 10 and 11. Just to put on the record that this includes a proffer of a covenant. The release of the 2018 former covenant will be done administratively. So I just want to put that in the record because there will not be 2 covenants. The intent is for the new covenant to replace, supersede, and be the only enforceable covenant on the land. Thank you.
Thank you. So,
And Madam Chair, on PZ 9, I believe the applicant's going to indicate Planning Department recommended denial of the T680 to T68L.
Which item is this?
PZ 9?
PZ9.
PZ.
The zoning change. Is that correct? You want to abandon the zoning from T680 to T68L and keep the change from T30 to T40?
That is correct, Mr. City Attorney. Good afternoon, Commissioners. Ben Fernandez, 200 South Biscayne Boulevard, on behalf of the applicant. That was the motion on first reading. This is second reading, and we continue to make that request. Thank you.
Thank you. So I have a motion and a second. All in favor?
Sorry,
Aye.
Chair. So who is the mover again?
You're supposed to follow that.
No. I just want to make sure that everyone's accepting the amendments that were proffered.
I
So
made the
Commissioner Reyes
motion.
moved the item.
Yes.
Commissioner Correa
So
seconded.
exactly, I'm sorry. What exactly are we doing again?
We're passing all of the items. So I have a motion.
16
Motion.
and 17, they are
First reading, yes.
First reading.
So if there
First
needs
reading.
to be some cleanup
No problem.
between first and second reading.
I want to know a lot of things.
All right.
Okay. I have a motion and a second. All in favor?
Aye.
Aye.
Motion carries unanimously.
With PZ 9 amended and PZ 10 and 11 amended.
Correct. We have a personal appearance that, Mr. City Clerk, do I have any other items on the agenda in play other than the personal appearance?
No, ma'am.
Okay, personal appearance. Can I make an announcement while we wait for you to do your personal appearance?
What announcement?
One announcement I have. Where's my staff? I hope they're listening to me.
You're running for sheriff?
No. I think this is the extent. IT, where's IT? Okay. IT. Hey. There we go. Here we go. While we get ready for the personal appearance, can you put that back? No. Can you put my flyer back just quickly? Yes, just I'm going to make a quick announcement before the personal appearance. I want to announce to everyone and my colleagues the Fit City Miami Challenge kickoff for May. May is National Physical Fitness and Sports Month. And we are putting forth the City Fit Miami Challenge for all city employees to get fit. The kickoff is May 6th at 4 o'clock at the MRC. We're going to do a 5K. And throughout the month, we are going to be doing health initiatives. At the kickoff, we're going to have workshops and all kinds of things. We hope that everyone, all of the departments, all of the employees participate. We hope that each commissioner participates and their staff participates. It's our attempt to help our employees get healthy both physically and mentally. There's going to be information on physical health and mental health. We're going to have hydration challenges. We're going to have a challenge you walk, run, bicycle 31 miles in 31 days. It's going to be a lot of fun. There are going to be prizes. I know we have 2 tickets to Rolling Loud donated for one of our winners. That's going to be a concert in December. And we're going to have all kinds of initiatives, incentives. There's going to be an opportunity for employees to earn administrative leave for accomplishments that they achieve during this fitness month. So I pray that all of you join us. There's going to be a department liaison in each department that can get more information on how to participate. And I hope all of you join me for the City Fit Miami Challenge, May 6th.
Well, to make sure that everyone's safe on the 5K run, Commissioner Reyes and I are going to volunteer to lead the run from the golf cart we're going to be in with the lights so everybody could see that you guys are coming and you're safe.
You can walk. You
Commissioner,
can walk.
we're going to have a lot of water for the people that needs it. I know.
Join me, encourage your staff to participate, and all of the city employees join us so that we can be a healthy city. Thank you.
Okay. You would have to say that after I had ribs for lunch, right?
All right? After the run, we go to a barbecue place. Okay, are we ready? All right, if you could put the first one up. Look, this is a presentation that I think is important for beginning with my colleagues up here, but for the residents to see what truly has been happening and what many people have to say about Maurice Ferré Park and Bayfront Park, and in particularly some of the key issues that have been heard from minority. This here is from Local Gems, Florida. This is a part of the Newsbreak digital news website and app that declared the top 5 parks in Miami-Dade County. And the number 1 park that they put in their very looked at Newsbreak digital website and app, the number 1 park was Maurice A. Ferré Park. And they said, nestled in the heart of downtown Miami, where the city's stunning architectural meets the vibrant bay, the park offers an impressive blend of natural beauty and cultural intrigue. The park, formerly known as Bicentennial Park, is teeming with lush green spaces, colorful sculptures, and a variety of flora, making it a paradise for nature lovers and art enthusiasts alike. Visitors can enjoy a leisurely stroll along the bay, observe cruise ships, or engage in outdoor events. The park also features a dog section loved by both locals and tourists, and is home to a science museum and planetarium. Despite its vastness, the park maintains impeccable cleanliness and offers ample parking and easy access, enhancing the overall visitor experience. Can we go to the first video that we want to show?
El Maurice A. Ferré Park, con sus extensas y cautivadoras áreas al aire libre, desde gimnasio para todos hasta el icónico Dogs and Cats Walkway, que a un año de su inauguración ha sido visitado por más de 300,000 personas. Nuestro Maurice A. Ferré Park ha experimentado una notable transformación, siendo nombrado el número 1 en la guía de Miami's Roller Coaster Ride por Local Gems de la Florida. En el Maurice A. Ferré Park, el arte cobra vida con obras imponentes de maestros internacionales como Jiménez Heredia y Manolo Valdés. En el Bayfront Park continuamos trabajando incansablemente para traerles los mejores eventos y muy pronto comenzaremos las obras para la reconstrucción de la emblemática fuente. Maurice A. Ferré Park y Bayfront Park, los parques de todo Miami.
As you can see, we will be bringing, God willing, before the end of the year, the fountain back. And we will be keeping the same fountain that Noguchi put there, and it's going to be beautiful once it's done and working. If you could go to the next video, please. Combination of what we all do at New Year's. Over 150,000 people came this year. Our New Year's event has become the second largest New Year's event in the United States and the biggest Latin New Year's event in our hemisphere. Next one, please. This is the Dogs and Cats Sculpture Gardens walkway that was inaugurated last year.
The sculptures are gorgeous.
Both Chairman King,
the background,
Commissioner
Cross
Reyes were there, and
Museum,
thank you
have
for
these
being there.
beautiful rose gardens. I mean, today for me is like the best way to spend the Sunday. And then, of course, with the family, you can't beat it.
I think it's very unique and very beautiful. I think it's very important for kids to explore new things and see new things. So it's definitely the most important thing in our life is art.
I love the park. It's so beautiful to be outside in nature, the sun, the exhibition with all of the beautiful like colors, the animals, the dogs, the cats. It's awesome to have this like right here in the neighborhood.
Just with my family, we came all the way down from Montana. This is beautiful. We were just noticing how awesome the artwork is. Just the artwork on each of the animals is so unique and different. I love it, especially the fire department one because I work at a fire department.
Spectacular. It's such an important thing for the city of Miami, and it made me really emotional because seeing all of these, first of all, it's so many different breeds and they're all so beautifully made, so it's a really great addition to the city.
Amazing. It is actually an oasis inside like downtown Miami. The moment you walk in here in the walkway is like a change of energy. The actual culture that it brings to Miami is amazing, so I really recommend it.
In the first year that the Sculpture Gardens, Dogs and Cat Walkway and Sculpture Gardens has been open, we've had some 350,000 visitors, more than the Paris Museum next door. Next.
That building.
I
love the park. It's beautiful. I come here every single day.
You could backtrack it, please.
I love the park. It's beautiful. I come here every single day.
From
It's
the beginning.
My name is Jesus. I live right there. That building.
Can you stop
I
and
love
start
the
from
park.
the beginning? Don't start it yet until I tell you. Just bring it back and then we'll start it from the beginning. Here, since I was told that when we have hearings on the exercise outdoor gym, we cannot bring in testimony from dozens of the people that not only live around there, but are residents of Miami that want to use it, the silent majority. I thought it'd be appropriate, and you should hear from them today briefly. So that you just don't think that everybody is against us. On the contrary, the majority of the people are for it. In the city of Miami, we have a total of 25 parks that have outdoor gym equipment and 3 more that are going to have it soon, for a total of 28. So if you could start, please.
I live right there, that building. I love the park. It's beautiful. I come here every single day. It's really peaceful, and in my opinion, it's the cleanest park in Miami, hands down. I am waiting. I'm just waiting for those fences to come out because I think I'm gonna really enjoy it. You know, you get some pull-ups done. I think it's great. Honestly, it's gonna really boost the park even more.
This is Arturo Sandoval.
¿Pero qué es esto? ¿Qué es esto? Esto está buenísimo y gratis y al aire libre para todo el mundo que lo puede usar. Ocupa poco espacio, pero ahora me acaban de decir que hay vecinos aquí que se opusieron a que abrieran esto aquí. De verdad que si alguien pudiera explicarme cuál es la razón, porque si tú dijeras, están haciendo un centro de vender droga, no sé qué cosa. Esto es una cosa para ayudar a la gente que no tiene a lo mejor el poder adquisitivo de ir a un gimnasio caro, que puede venir aquí y usar todos esos aparatos para hacer ejercicio gratuitamente. Eso va contra toda lógica.
I'm Jenna Athos, and I like this park. I think I go to the gym a lot, and I think being outside is even better. So an outdoor gym combines the two.
¿Sabe, Cristina Catano? Me encanta. Me parece maravilloso, me parece muy variado, me parece que es una oportunidad y te estimula a animarte, a hacer ejercicio, a estar activo. Al mismo tiempo puedes disfrutar del parque y tu esposo, tú misma puedes ir a tener unos minutos de ejercicio, maravilloso, lo que todo el mundo necesita. Un privilegio, eso no tiene nombre. ¿Ustedes saben cuánta gente en este mundo soñaría con todas estas máquinas? ¿Cuánto tiene que pagar uno de membership por ser parte de un gimnasio? Y tener esa oportunidad variada, de todo tipo de aparatos, para poder uno ejercitarse al mismo tiempo que sales con tu familia, al mismo tiempo que tienes tu perro, al mismo tiempo que estás al aire libre, maravilloso.
Cristian Rojas, parece bien. En Colombia también hay bastantes gimnasios como esos y dan buenos resultados, mejoran el ambiente y hace que vengan más personas a los parques. Hace que la gente promueva el deporte, genera salud y pues en un ambiente abierto, hasta hace que se una más la gente aquí, la población de Miami con los turistas y demás.
My name is Nick. I guess for anybody that wants to use the gym, I think it's very unique. Like, if they don't have access to a gym, to use the park for free. Even using the track to run as well. I think that's a very good idea to use it.
Mi nombre es Estefanía. Excelente. Ahora pasé y dije, wow, porque súper asequible hacer una trotadita y después irse a hacer pesas y las máquinas están buenísimas al aire libre.
Andrés Felipe Cárdenas. Pues a nosotros que nos gusta el ejercicio, pues podemos venir a hacer ejercicio ahí, es muy bonito también, o sea, el parque es muy grande, de pronto más cosas para niños, el tener esa oportunidad de tener un gimnasio al aire libre, donde uno pueda hacer ejercicio, venir a trotar, ver la naturaleza.
Libby. Yeah, it's a fantastic thing, yeah, and just to inspire people to if they haven't exercised yet, to get started, absolutely.
Hola, mi nombre es María Carolina Echeverry y bueno, estamos aquí disfrutando de este parque tan maravilloso. Nos encontramos con este gimnasio que me parece que es un privilegio para toda la comunidad de acá de este lugar. ¿Cuántas personas quisieran un gimnasio como este en su comunidad, en su parque? Mucha gente tenemos que pagar gimnasio, pero el saber que esto está aquí nos incentiva a mejorar nuestra salud física, a hacer ejercicio con nuestros hijos, nuestra familia. Súper chévere, me encanta.
Mi nombre es Omar Vizquel. Oye, me parece maravillosa esta idea que todo el mundo venga a recrearse mentalmente, sanamente. Creo que esta es una iniciativa buenísima que deberían adaptar muchas de los pueblos, ciudades que están así alrededor de mar, alrededor de un ambiente tan bonito como es este parque. Y me parece la idea estupenda. Ojalá que amplíen más, porque la verdad que es un lugar reducido y lo veo maravilloso.
Hola, mi nombre es Carlos, vivo en el área del parque y siempre vengo con mucha frecuencia por aquí. Bueno, es un parque muy lindo, siempre frecuento aquí con mis amigos, con mi mascota, con J-Lo. Y bueno, ahora estoy gratamente sorprendido con las nuevas instalaciones del gimnasio. Sin duda, es una excelente idea, así que voy a venir con más frecuencia. No tenía pensado venir a hacerlo, pero lo voy a venir a hacer ahora. Me parece una brillante idea, siempre es una excelente oportunidad para todos los residentes del área, así que felicito a los encargados, a los responsables de este gimnasio tan cerca, ¿no? Tan conveniente para los residentes que estamos frecuentando esta área.
Dan,
Yeah, I do. I live up here in this building over here. I love it. The constant progress in the park is incredible. It seems every month they're adding something. They're adding this, look like outdoor workout area now. The palm trees have been added. There's lights they add all the time. There's constantly updates, constantly. It's amazing. It's incredible. Very, very positive. I think it's increasing the value of the area.
My name's Barbie. I think it's awesome. I think people that for like the gym, honestly, like people that don't have access to gyms can use that, and that's amazing. Like somebody that wants to get stronger and can't afford a membership, that's perfect, you know, I think.
Me llamo Jonil. Sí, para la comunidad muy bueno realmente, ¿entiendes? Porque es algo que todo el mundo tiene acceso ahí. Bueno, eso bastante bien. Realmente es una muy buena opción, como dije, ¿entiendes? Al final, nada, eso es lo que necesita esta ciudad. Cosas así, que todo el mundo tenga acceso a ella. ¿Entiendes?
Tracy. I think it's great because it really makes community space.
Hi, how are you? I am Denise Ducati. I actually love the gym because I am a personal trainer for 20-something years, so I think that's a great attribute for a lot of people. Sometimes you got basketball courts that doesn't hit everybody, and sometimes a tennis court or something else, but I think the gym outside gives people a different range of motion. Everybody lives in Miami, so we like to be outside. Sometimes being trapped at a gym doesn't do it for you, but it gives you a place to socialize because a gym technically is an adult playground.
From Hernandez, my opinion for the gym of this park is amazing. I think that's a great idea to bring more people to this park.
June, Valentine, I think it's great. So I can, while I'm working, I can stop by here, sit down and do a couple lifts. I don't see anything wrong with it.
Hola, Javier Cierco. Vivo ahí en One Miami. Cada vez se están haciendo arreglos y mejoras, que la sigo con interés. Ahora el nuevo gimnasio. Excelente, estoy frito porque la abran. Pues, a ver qué día ya la abren, porque creo que es muy bueno. Y con las personas que conozco aquí, que venimos todos los días, lo hemos comentado muchas veces, ¿no? Oye, sería bueno que pusieran algunas máquinas, alguna cosita. Y lo que han hecho es un gimnasio súper completo, porque hay como, no sé, 30 máquinas o más. O sea, que está súper bien. Súper bien.
Christina, yeah, I think that's such a great idea.
Jorge Espinosa, aprovechar las áreas verdes para el tema de entrenamiento y la salud me parece excelente.
Iván Arena, al ser algo público, sí es un privilegio que pues, a la comunidad en general se le da, incluso a las personas que tengan gimnasio, pronto sus edificios o personal, también es bueno a veces al aire libre.
My name is Raul Segredo. I live at 3206 915 Boulevard. I am for the Maurice Frey Park Trust and the improvements they're making in the park, including the gym.
Ari, and I live here at 900 Biscayne Boulevard.
Another 900.
That's right here. I think this park is an amazing asset for the city. You know, you see here the people, the kids, the activity, all the effort to bring life into this park, to bring more visitors, the statues, the gym is really, really nice.
Claudia Patricia Arenas. El tema de que haya este tipo de gimnasios es que es inclusivo para todo el mundo. Si no tenemos el presupuesto, podemos venir a practicar y sobre todo al aire libre. Porque puede que lo tengamos en los edificios, pero no es lo mismo.
My name is Hannah Borikov.
It's really nice. I think it's a way to get the community involved because it's, having a public space is really important, especially, incorporating healthy stuff like working out and all that. Where I used to live, they had the same thing, and it's just a great way for people to come together, I think.
Gley Montoro, excelente. Nunca me imaginé que lo iban a hacer y me parece extraordinario.
My name is Marcus Faliette. I love this park. I come here every single day with the puppy. Without it, it's like the only grass in downtown, really. So I use the dog park. I run around out here. I work out, so I'm very excited that this park's opening up as well. I think it's good to have an outdoor gym on this side because the only other outdoor gyms I know of are Muscle Beach. So this is probably the first one on this side that I know of.
Sam, great job in the park. It's absolutely amazing. All the statues and stuff that you guys put up and just how clean everything is, it's awesome. Yeah, you guys have done a really good job. Beautiful. And then this, I didn't even realize that this was here, to be honest with you. Yeah, the gym, yeah. This is cool.
Mi nombre es Sander y como saben yo soy residente aquí en Parque, vivo en Marina Blue. Yo no había visto lo que están haciendo aquí en el gimnasio y toda esa área que están haciendo de actividades.
Hi, my name is Daniel Valiente. I'm a downtown resident, and the new addition to the park is very accessible to kids, adults of all ages, and it seems like something that's going to attract a lot of people. It's next to the dog park, so it's a nice little family event that everybody can enjoy.
I'm Elizabeth. I live here in Marina Blue, and I am every day in the park with my dogs, and I love what they're doing, the trees and everything is going to be beautiful. It's going to be the best park in Miami.
My name is Eli. I live around this beautiful park. I saw a lot of change here, and we enjoy what is going here, and hopefully everybody enjoy like me, and really I am very, very happy.
Hi, my name is Eliza. I'm a resident here in Miami. It's a lovely park. I come here with my dog a lot. The dog park is amazing. It's always really nice and clean. And there's been very friendly people always every time I come here. It's nice being right on the water. And I've noticed all the nice improvements with the trees and the new foliage. It's a really nice place to be.
My name is
This was only a small group of people that we selected to show you, but 36 or so. There's many, many more that feel the same way. And as you can see here, these are people that basically all of them live in our city. I would say a majority live in downtown. You can see many of them that were speaking with their dogs coming there from across the street. The guy that was in the fence that spoke with the head, it's Arturo Sandoval, Grammy winner, one of the most famous Cuban-American musicians in the world and beyond. Arturo has been an owner for a second home in 900 building. And he can understand, as you heard there, why this gym was still fenced and he couldn't use it. You saw that there were numerous other people that lived in the 900 building, many others in downtown. So I wanted to show the other side of the silent majority that want an outdoor gym, that want to be able to have something different that they can enjoy and exercise with in open air, while being respectful of other people's opinions. You know, in a democracy, you try to make room for everyone that you can. It's just not a few that should be able to dictate for the majority. But we also wanted to show the sculpture gardens and dogs and cats walkway so you could see what was done there. 2 whole city blocks of the most beautiful gardens anywhere in Florida, with 57 statues, all painted by local artists. At the same time, there's a lot of work that's gone there. We have the largest dog park in the state of Florida, Maurice Ferre Park. We built another dog park at Bayfront Park. The work that goes on for the New Year's Eve celebration that we give to our residents and beyond every year, I dare to say no other city in the world can do it. We begin at 6 p.m. at night and go until over 1 in the morning, where we have close to 30 artists that perform. And for the most part, they're all known artists. Many are world-renowned artists. Huge amount of Grammy winners that we have to perform. And we have to make room for 150,000 people to come, beyond hundreds of thousands that see it in TV or in YouTube in Miami and around the world. So I wanted to take this opportunity, and I thank the Commission for giving it to me so you could see what work has been done at Maurice Ferré and Bayfront Park. These are regional parks that are parks for all the city of Miami. These are not neighborhood parks. These are regional parks that are there with the museums for all Miamians to enjoy. The Dogs and Cats Walkway and Sculpture Gardens is brought positive publicity to Miami worldwide and nationwide. And there's nothing like it in the world. And people that come to visit Miami go there just to see it. So I again thank you, Chair, Commissioners, for being able to bring this presentation.
Thank you. And at this time, we shall conclude the City of Miami Commission meeting for April 25th, 2024. Thank you all.